jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
This courtroom session starts off like any other, but within seconds, it becomes clear this is not just a routine hearing. We're looking at a defendant already on probation, now facing a new felony charge, and a judge who has clearly done her homework. But here's where things get intense. This case isn't just about the crime, it's about behavior, attitude, and accountability. Watch closely, because what unfolds here shows how quickly things can spiral when a defendant fails to read the room. Will this plea deal hold, or is it about to fall apart in real time? Let's break it down.
More time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep saying. Let's see. So we are going on the MTRP in one new case. Let's go with this new case 25. So, good morning. Are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Give me a second. Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me.
Right away, the judge is signaling something critical. She's focused heavily on the defendant's conduct while in custody. That's a major red flag. Jail behavior reports can significantly influence sentencing decisions, especially when someone is already on probation. This isn't just about what happened on the street, it's about patterns of behavior. And when a judge emphasizes documentation like this, it often means the defendant is already starting at a disadvantage. Ask yourself, should behavior behind bars carry as much weight as the original crime?
When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you?
No.
Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally.
This moment is powerful, and honestly, a bit uncomfortable. The judge directly calls out the defendant's attitude, contrasting his quiet tone in court with alleged aggressive behavior in jail. This is more than just a reprimand, it's a warning. In court, demeanor matters. Judges often interpret behavior as a reflection of remorse, respect, and credibility. If a defendant appears dismissive or inconsistent, it can completely undermine their case. So here's the question. Do you think the judge is being too harsh, or is she holding him accountable for behavior that truly matters?
So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea.
Now this is where things get legally serious. The judge makes it crystal clear, she is not obligated to accept any plea agreement, especially since the defendant is already on probation. That's a huge point many people misunderstand. Plea deals are not guaranteed outcomes, they require judicial approval. And when a judge feels the defendant isn't in leniency, they can reject the deal entirely. This shifts all the power back to the bench. So imagine being in that seat. Would you risk rejecting the deal and facing a harsher sentence?
Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 21-37857,
Your Honor, it's a second amended. Just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13. 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh,
count 20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot with,
Okay.
with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct?
Yes.
And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true?
True.
What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending. The misdemeanor.
The failure ID is still pending next door, Judge.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else that like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. So, let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations. So I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my Same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail.
And just like that, the first major decision drops. The judge accepts the plea for the new charge and hands down a 5-year sentence. But don't let that number fool you. This isn't the end, it's only the beginning. Because right behind this comes the motion to revoke probation, which could carry even more serious consequences. This is a classic legal domino effect, one conviction triggering another. The real question now is, how much more time is about to be added on top of this?
Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. Community service is slavery? Do you think that?
No.
It's the same. I'm not taking 5 on the NCRP. I've already taken 5 on.
This is one of the most shocking moments in the hearing. The judge references inappropriate behavior toward a probation officer, something that goes far beyond a simple violation. This kind of conduct not only damages credibility but signals a deeper issue with judgment and respect for authority. And in the courtroom, that's a dangerous combination. The judge is essentially connecting past misconduct with present behavior, building a pattern. So let me ask you, should personal behavior like this influence sentencing, or should the court focus strictly on the legal violations?
So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different. But I'm not going to do that. Let's see. So I already did that one. All right, so we are back on the record in cause number 21-37857. And again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the...
The new agreement is 8 years TDC.
All right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you sign, and you fully understand them also. And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank
All
you.
right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before.
Here's the turning point. The judge outright rejects the original 5-year agreement for the probation violation. That's a bold move, but one completely within her authority. She's sending a clear message: repeated behavior will not be rewarded with leniency. Instead, she pauses the proceedings to give both sides a chance to renegotiate. This is courtroom strategy in real time. The defense now has to reassess quickly under pressure. So what would you do? Push for a better deal, or brace for a harsher outcome? And there it is, the final outcome. The defendant ends up with 8 years after the renegotiated agreement, running concurrently with the earlier 5-year sentence. This case is a textbook example of how behavior, both inside and outside the courtroom, can dramatically impact legal outcomes. The judge exercised full discretion, rejecting an initial deal and pushing for a stricter resolution based on the defendant's conduct. It's a powerful reminder that accountability doesn't stop at the charges, it extends to attitude, respect, and actions at every stage. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments,